Well, thanks, Jacinta. Those family law stories are always interesting. My side of things, the superannuation update might not be quite as exciting as Jacinta's, but we're still going to move through the afternoon, see if I can come up with some juicy stories for you too, what happens in the self-managed superannuation fund space. So, for those of you who are here a year ago, we were in that in the middle of that 9-month election campaign. Remember that? And we had a Labor government who was announcing all of these measures, but weren't very good at drafting the legislation for getting those measures actually passed. We're more good at making the announcements. And so I was a bit sceptical about what legislation and announcements would actually get through and what wouldn't. And so, just briefly today, what are the ones that didn't get through? The tax on the pension earnings over $100,000 in the self-managed super fund. That new ruling on the new rules in '66 on the related party acquisition. So remember that was going to start in July 2012 and then again in July 2013, saying, well, your off-market buyback or off-market transfer of shares from your personal name to the super fund were going to have to be done on market. And there was a whole bunch of issues that were raised there, so that's been canned by the coalition government. There's other smaller things, such as verification of bank account details, your anti-money laundering rules for getting the money, your superannuation money between funds. That's been thrown out the window too. Those tax concessions to encourage those deferred lifetime annuities, they're also out the window. Taxpayer Alert 2010/2, that was a taxpayer alert about certain clauses in trust deeds, and those clauses would say, if a trustee receives an excess non-concessional contribution, you know those ones where you get those big excess contribution tax assessments, we've got a clause in our trustee that says, well, if a trustee receives one of those, once it finds out about it, it doesn't hold that on the trust of the super fund. It holds it on trust for whoever contributed it, and will give it back as soon as it finds out about it, or as soon as practicable after it can find out about it. The ATO put out this taxpayer alert saying, oh, we don't think that's right, we don't think you can do that. So that's been scrapped too. So it's better to have the argument in your trust deed than to not have the argument. So the rules are in for your refunds of your excess concessional contributions. The coalition government said we're amenable to the idea of some kind of amelioration, some kind of changes to the excess non-concessional contribution taxes, but they haven't been announced yet. So I'd still recommend that you have these kind of clauses in your trust deed. So if you do accidentally make one, you've got a good argument to get it back out without incurring that really high excess contributions tax. What is proceeding? So introducing those CIS penalties for your promotion of early access schemes. So typically these have been touted in your Western Sydney to your immigrants who might have their $20,000 in super. Hey, set up a self-managed super fund and then you can take all the money out of the super and spend it on your business. And, of course it's illegal. It was always illegal, but the CIS Act never had anything directly against the promoters for that. And so now that's directly in the CIS Act. There's criminal penalties and fines of up to $340,000 for that. But you have a look at the legislation. It's any advice recommending or facilitating access to superannuation other than in accordance with the standards. So, for example, you might have had someone who was about to go bankrupt, and you say, well, we don't want to pay a lump sum to you now, but let's lend some money, and take security over your house from your super fund. Is that early access to you? Is that access other than in accordance with the rules? Well, perhaps, and could the promoter get tied in on that? Perhaps. So tread carefully for any of those kind of advices if you're encouraging early access or loaning of those super fund monies, because you could get caught under these rules, particularly if ASIC or the ATO don't like it. And it's ASIC who's in charge of enforcing those rules. So you'd think ASIC's more after the big end of town than the little advisors, but be careful of it anyway. Back in 2010, for your super fund borrowings, they announced it wasn't an announcement, Treasury released a paper saying the big end of town set these documents up wrong. And technically in a lot of these documents, when you pay off the loan in a super fund borrowing, that could be a tax event, a CGT event at that point. They said, but we recommend the legislation be changed, so we look through those warrant kind of structures. And that was in 2010, and 4 years later we still don't have the legislation. But the coalition said that's back on the agenda, and they're going to draft something up, so we'll see how they go. This is a big one of penalties for self-managed super fund trustees. When I was talking to you last year, it was supposed to commence on 1 July 2013, but it never got passed in time before the election. But it's passed Parliament now, it's got in the Royal Assent, and it's commencing on 1 July 2014. And so that is that the ATO can, against self-managed super fund trustees, can administer a range of penalties I'll talk about soon, can also do rectification orders. So instead of having to accept an enforceable undertaking from a trustee, can instead make those trustees take in a certain course of action in a certain course of time, or otherwise there's fines and penalties that will apply, and then they might go to that next stage of going to court. Traditionally, the only power of the ATO to now has really been over the top. It's been, we can make your fund non-compliant, and that's half the assets of the fund basically being lost to tax. Or we can spend a lot of money going off to court to get civil penalty orders against you. And in all of those cases, it doesn't really gel well with the retirement system. Self-managed super funds are there to try to maximise the retirement benefits for the members. If someone's made a minor mistake with their super fund or stuffed up with one of their borrowings, it's not really fair that their whole retirement savings are thrown out the window. This new regime will really allow a punishment to fit the crime. And we might see it might even be a bit revenue raising for the ATO, so they might be quite interested in enforcing these fines. Non-concessional contributions, so they're going up for years since the Simple Super got introduced. They've been at $150,000 per annum. And if you're under 65, you can do that bring forward, so have a $450,000 contribution for the following 3 years. That's going up on 1 July to $180,000. So that's $540,000 with that bring forward rule. So if you've got clients who really want to pump prime their super around the moment, you might be thinking $150,000 in June and then $540,000 in July. And they can't make any of those non-concessional contributions for a few years after that. But you're talking a couple's able to get, 1.3 million or so into super, just using your non-concessional caps. You're not even talking about your CGT caps yet. So there are people, in your 50s, there's still really that opportunity to pump prime your super later in life. And then those concessional contributions caps, those for the 59 and over was 35,000 this year, and it's 49 and over at 30 June 2014 for next year. The rest of us are still on that $25,000 level. So here's your fines and your penalties for trustees. And so you have a look there. This is just, I got this courtesy of Professional Planner, and this is historically what the number of contraventions have been in these different areas. With the smaller auditors being forced out, so to speak, the number of these contraventions reported could conceivably go up. And so extrapolating what the number of conventions and the fine in the legislation are, they're talking, what's that say? 145 million of fine revenue. Doesn't sound like a whole lot in the scheme of things, but the ATOs, at least with all their officers and investigators, etc., they get an audit contravention report. It might be just a simple process now, issuing that fine, and it's good revenue collection for the ATO. So really have a look before June this year. If you've got those ongoing breaches, a good idea, if we can, to fix them up while no fine's going to be imposed, because otherwise they might be copying, your clients might be copying a fine each year, and they always like to blame someone, don't they? And they'll always be looking at their advisors to blame. What's interesting here, you've got your different levels of fines for your different offences. Now, I'm not sure, and we don't see until the ATO puts out a practice direction, perhaps they've got some discretion to not issue that maximum fine in the legislation. Perhaps they could issue smaller fines. But at the moment, we're just treating it like, for example, a loan to members would be a $10,700 fine. Now, I'm always talking, and a lot of advisors are always saying, hey, you're setting up a self-managed super fund, use a corporate trustee. All the reasons we've said before for that, ease of new members, better estate planning, etc. But these penalties are another new reason to have a corporate trustee for your self-managed super fund. Because what it says is if you've got individual trustees, they're all liable for the fine if they're responsible for it. So the example is, let's say if there was an in-house asset breach, it's a $10,700 fine. Now if you had the kids in your fund, so you had 4 trustees and 4 members inside your self-managed super fund, it's 4 by $10,700. So that's all up and over a $40,000 fine. You had a corporate trustee, the directors are jointly and severally liable. So that's one $10,700 fine. You know, you divide that between the four of them, it's $2,500 each. It's a big difference, isn't it? So none of us are trying to breach the rules, but geez, it's pretty cheap insurance, isn't it? $50 a year, ASIC fee or whatever it is, for a self-managed super fund trustee just to have that corporate trustee there. Brings us on to, I guess, well, what are some issues with corporate trustees for your self-managed super funds? So, your replaceable rules in your Corporations Act 250F, and most constitutions I read, apart from specifically tailored ones, have this provision in there. And that is when there's a joint shareholding, and both of those parties who represent the joint shareholding want to vote, then you only count one vote. They don't share the vote, they don't get half a vote each. You count the first named in the company register's vote. And so you can see that that could possibly cause some problems, especially when people are fighting or you've got an executor. For example, executors are trustees, so they're joint. It's a joint appointment. So typically your executor inherits the shares in the company and they're jointly appointed there. Your executor's got certain trustee duties that they've got to comply with, but you're still looking at the letter of the law, the constitution. This is a real problem, isn't it? So you have a look at Mary and David. They're members of their self-managed super fund. And they're both directors and joint shareholders of the corporate trustee. And so then David wants Mary out, so he looks at the constitution and calls the meeting that he's allowed to do, and he sacks her pursuant to the constitution. So he's got the 17A issue, but there's no breach of the super law there. It's still a self-managed super fund as long as he gets Mary out of there within 6 months. And then does the deed have provisions in it to, force the rollover of Mary's benefits? Also got to be careful there though, there's trustee duties, there's director's duties, got to act in the best interest of the company, etc. But the letter of the constitution, that might be a course that he's able to follow. Another example of Zed. Zed's dead. And so his wife B and he's got 2 children, C and D. And so they're all executors. And again, in this case, Zed owns 1 share and his wife B owns the other share in the corporate trustee. They're both members of that super fund. There's no binding death benefit nomination. Under his will, Zed gives his house to B and the balance including his super to his children. What do you think happens? So, in this situation, you've got B there. She's the continuing director of the corporate trustee, isn't she? There's no binding death benefit nomination.
Doesn't matter who's the executor.
So, okay, who's the executor? What is the executor typically?
The will,
unless the deed says the executor automatically becomes a trustee, okay, they're not on there. So let's have a look at the shareholding. What is it? There's 3 shareholders, you'd think, wouldn't you? B, C and D. But if B's name's first on the register, well, she's the one who gets the vote. But let's pretend B's not even on there. Let's pretend for a second that B wasn't an executor and it was the 2 children, C and D, as executors. How do they get appointed in control of this Zed Super Pty Ltd? How many shares do they own? They own 50% of the shares. And unless there's a special shareholdings in the constitution, 50% of the shareholders isn't enough to call a shareholders meeting and appoint yourself as director. You need 50.1. You need a majority to be able to do that. So even if B wasn't an executor, she would still be in absolute control of that company and in absolute control of that super fund. And so therefore, she's got the discretion, she can pay out those super benefits to herself. Which brings us to the evil stepmother. I was thinking about this before I presented it. I thought, oh, this is a real case. I wonder if the evil stepmother will see this and they won't like it and will have a go at me. And it ends up when I was talking in the Gold Coast that one of the people there was his client, the evil stepmother. And he thought I was a bit harsh on her. But she's passed away now, so she can't see me. So, you got your evil stepmother. The kids from the first marriage always think they're pretty good at picking the evil stepmother, don't they? They pick it early on.
The husband doesn't necessarily. And there's always a fight. Which one's the evil one? And that's what family is. That's, you know, the world of your second marriages and kids from your first marriage, etc. That's what we're dealing with. And so, in this case, Max was married to Patricia, and Patricia was his second wife. They were joint trustees and members of the Morris Family Super Fund. Max made a binding death benefit nomination in 2008 in favour of his daughters from his first marriage, Susan and Kerry. Signed by the two witnesses, you know, appeared to be a nomination, you know, signed properly, etc. Max died in February 2010. And so then Patricia, she needs two trustees of the fund, so she appointed her son, Nathan, as co-trustee in October. And at that stage, the accounts were showing $1.3 million of total super assets. Max's death benefits were $924,000. Patricia says that she's not real keen on paying the death benefits as per the binding nomination, and she says that she wasn't delivered that binding death benefit nomination in accordance with the deed. And at saying this, she goes off to a law firm, DLA Piper, who give us the advice, well, we don't think the nomination's binding based on your instructions. So it ends up there was a big fight. So she put in a new corporate trustee, and obviously Nathan, the son, probably didn't want to get involved in this big fight and risk of legal fees in his own name, so that's why they would have changed it to a corporate trustee that she was the sole director of. And so there was a big fight. The kids were saying, hey, we got a binding nomination. Dad wanted to pay his super benefits to us. We've done the right thing. There's a binding nomination. Why won't you pay it to us? She's going, I got this advice. And so then they spent a lot of money and they decided, well, we'll go off to a senior counsel to decide it for us. So we all agreed that the senior counsel would be the referee. And in no uncertain terms, he found that the binding death benefit nomination was binding, and the daughters were owed the $924,000 plus the interest at the statutory rate, rather than, you know, the interest actually earned within the fund, and costs. So the costs can add up in a dispute like this pretty easily, especially when you've got people who really aren't acting in everyone's best interests and looking after themselves. And so the trustee, when they were paying for the legal costs along the way, was saying, well, that's really should all come out of the husband's account. It shouldn't come out of the general superannuation fund account. So we've only got $600,000 that we can really pay pursuant to the senior counsel's determination. And so they had consent orders to pay that $600,000. And after that, so there's only $75,000 left to pay Max. So not almost enough to pay the interest and the costs and the balance, $324,000. So that's where the fight was, is, well, where does the rest come from? And so that's where we go off to court. And reading the judgment, it's saying, in that year, so this went to court in July, I think the hearing date was last year. And so they must have had some good accountants, because the June 2013 accounts were prepared early in July for the self-managed super fund. So everyone, that's a new standard you should hold your accountants to for your self-managed super fund. But the accountants paid a hefty fee, charged a hefty fee. In that year, they charged $50,000. And the lawyers for that year for the fund charged $300,000. So I'm not sure what it was for the prior years, etc. But the fund was chewing through some money. And in the judgment, it did say, oh, there's some problem face the evidence that she was actually putting some of her own legal bills, or, you know, they were for personal matters through that super fund too. But so, you know, that's the fight over, you know, where are all of these costs getting paid from? Is it fair to the stepdaughters? And so the judge found, well, yes, the binding death benefit nomination was binding. And what he said too is, he said, well, she's really in a massively conflicted situation. She was a trustee of this fund. And then she decided on her own bat, really, to give instructions that she thought she didn't receive it properly, and it wasn't binding. And that was to benefit her. And so what he's saying is, if she wanted to really step down from this position of conflict, what she should have done is she should have gone off to the court at that point, if she thought it wasn't binding, and got a declaration from the court. Is this binding death benefit nomination binding or not? There was many offers for her to settle along the way. The daughters were saying, oh, we'll accept, you know, a lesser amount. You don't have to pay it, you can have a bit yourself. But she ignored those and she decided to litigate it, and he said again, should have gone back to the court and got an order, is this appropriate for a trustee to be carrying on in this litigation and incurring these costs? If it's not appropriate, well, it can be a breach of trust, and you're not entitled to that indemnity from the trust. Well, so in those circumstances, it was one of those circumstances where the court thought, well, we'll order it over the whole of the assets of the super fund, and if that's not enough to pay all of the costs, we're ordering it jointly and severally. So also over Patricia's own name. So, you know, she could pay for her house. And so I was told by the person whose client it was that, yeah, well, it was a sad story. She was a nice lady, and her daughters from her first marriage didn't get anything. So there we go. Now, your deficient estate planning, here's another case. And so in this one, Mrs. Conti, by her will, again, directed superannuation benefits to her daughters and not to her husband. She specifically said they're not to go to my husband in her will. The daughters were the executors under her will, and so Mr. Conti was a continuing trustee and member of that self-managed super fund. Was he entitled to pay those benefits to himself and ignore the will? Yes. I mean, it's settled law, isn't it? Katz and Grossman, we've already had that case. Then they said, well, it's not just that, really. The daughters were executors, so they should have been able to been appointed as, they should have been appointed as co-trustees. He shouldn't have been allowed to put in a company that he was the sole director of. They said, well, that's not the case at all. That's not what 17A says. 17A just says this is what's required to be a self-managed super fund. Unless the deed says there's some automatic appointment of the member's legal personal representative of his executor, it doesn't happen. Then they said, well, did he actually act bona fide in making that determination to pay those monies to himself? The deed required that. And, well, yeah, well, they found, well, there was actually 2 binding nominations that had been done in the past, but they were those lapsing ones that lapsed after 3 years. And there was one even at the same time that he signed this will. So the super directions in the will were never going to work. Queries, you know, what advice was given at the time. And so that wasn't allowed either. And then she was looking, well, the court should use its inherent jurisdiction for trusts to step in and make an order to the daughters rather than the husband. And they said, look, this is allowed, the super deed allows it, we're not going to go and do that. And we're not going to go and appoint the daughters alongside the trustee company, because all that would do is it wouldn't resolve the litigation at all. It would just mean you've got 2 totally opposing views on that trustee level. This is something he was entitled to do and you know, done it. So what we're looking at here is really, these cases are showing it's not just doing a binding nomination. That's not enough. You might have someone who doesn't like the binding nomination and doesn't want to follow it, and you might have big litigation and big costs and big family fights doing that. You've really got to look who's going to take control of the fund, who's going to become trustee to pay out your benefits and do that. And that's a step you've really got to take too, and make sure you get it right. Which brings us to, well, if a tree falls in the wood and no one's around to hear it, does it make a sound? Does a binding death benefit nomination exist if no one can see it? And, you know, I think we're naive to think this doesn't happen. You got husband and wife, they're joint trustees of the super fund, and they give binding nominations to each other. Often, I've seen them, they come out, they're at the back of the deed, Schedule 3 of the deed, fill out your binding nomination. Here's your binding nomination, just sign it. At the, you know, sometimes it's sent out by the super fund administrator with the accounts. It's not with the world, it's just between each other. Is it conceivable that someone who doesn't want to pay those benefits to the children might not tell the children about that binding death benefit nomination? I think it probably happens quite often. So that's where us lawyers get engaged, challenging binding death benefit nominations and the pensions. Hey, I don't want to follow this binding death benefit nomination. So you have a look. Let's have a look at all the super deeds. Have they all been signed correctly? Have they all followed the process? Was there a deed of variation that didn't contemplate the old binding nomination? And so the nomination's no longer binding under the new deed? All of those kind of aspects, you know, I've seen some deeds, pro forma kind of deeds from some of the big trustee providers. They require you to send out notice to the trustee before the nomination. It's got to set out all of these various considerations and all the information that the trustee thinks relevant. That's got to be signed. You know, you've got to send that back to the trustee, wait a certain amount of days. Then the binding nomination's got to be signed in a certain manner, and then it's got to be accepted in the trustee in a certain manner. And the form's got to be on a certain form. Took us about an hour and a half to draft all of these documents. You know, someone trying to do it themselves, it'd be pretty hard to comply with all of these meticulous requirements in the deed. It's better to have a deed that doesn't, make you go through that kind of process. But if you don't follow it, your binding nomination can be challenged and might not be so binding. So, I heard a lawyer the other day, referring to one of the lawyers in these cases, and they called him a wealth transfer file. So it's not the wealth transfer file from the parents to their children from the first marriage. It's a wealth transfer file from the parents' estate to the lawyers. Hopefully, you get the right estate planning done to start off with. It's solid and you can avoid that, but you never know about evil stepmothers and what can go on. Tax effective super to children. This is just a case often we get asked, hey, I want to pay some of my super straight to my children, whether via the testamentary trust or directly when I die. I don't want to wait until both myself and my spouse die. And so in this case, you've got Jack. He's got an $800,000 superannuation balance, and it's all taxable component. So if he was going to pay any of that out to the kids, they'd be paying that death benefits tax of 16.5%. What's a way he can restructure his super? He's reached that retirement age, he's reached the condition of release. So what he could do is he could make a lump sum tax-free distribution out to himself. That's of the $300,000, there's $500,000 left in his super, 100% taxable. Starts a pension over that, and he directs that pension's going to end up with his wife. Then he recontributes that same $300,000, that's 100% non-taxable because it's a non-concessional contribution. Starts a pension with that, and that's directed to the children. And so there's no death benefits tax on that. It's just split up those taxable components. So that's the trick to do that. With your pensions inside a super, it used to be if you had mum and dad were both in pension phase, mum died, and then dad died, and so then you're trying to get those super assets out to the kids. They were saying, well, that reverted to accumulation phase. So when you were selling the property and selling those things, you were still paying that 15% tax rate. The law was changed in that regard, which is good news, as long as you pay out the death benefits as soon as practicable. For tax purposes, the superannuation still stays in pension phase, so there's no tax paid on selling the properties and paying out those death benefits. There is an example, though, for the insurance where you're trying to get that out. There still can be some tax paid in that example. So use of reversionary pensions for those insurance policies can be handy to get it out to the kids. And just finishing here, last up, beating the bank. So for asset protection, we're usually telling people, look, you can't beat the bank, with the mortgage on your home and the mortgage on the business. They're always going to be the first to get paid. So Mr. Rowley, though, looks like an astute financial planner to me, apart from going bankrupt. He seems like he did beat the bank, and I think Macquarie Bank might be a bit embarrassed about this one. So this was another case last year. And so he owned a financial planning business, and he borrowed $2.5 million from Macquarie. The purpose was to make these super contributions. So he went and got the right remuneration report so he could get those eligible service payments made to himself, quite large ones, and his wife, and then had the kids pay, and then the concessional contributions back then were about $100,000 each too, and then pump priming the kids up also. Now getting that also was deductible to the business. Macquarie was complicit with all of this, and then though, Mr. Rowley went bankrupt. And so the business has gone bad, and Macquarie's appointed receivers to the business. And I go, well, Mr. Rowley, you certainly haven't acted in the company's best interest by making all of these contributions to super. I said, well, you knew about it. You're the one who gave me the loan for this amount. And so the judge actually found, well, no, he didn't act in the best interest of the company. What Mr. Rowley thought was acting in the best interest of the shareholders, i.e. him and his wife, he thought that was also in the best interest of the company. Well, the court said, well, no, that's not really the case, because the company's gone bust because of borrowing this much money. And then it was a trust, so they're having a look, well, what are your fiduciary duties? And they're saying, oh, you didn't really consider all the beneficiaries of the trust, and we don't think you've complied with fiduciary duties. So they found against him on all of those counts. That's good, not too good for Macquarie, though, because he's bankrupt. So the judgment against him it isn't really worth too much. You wouldn't spend all that money going to court for that. So it's that next level, trying to go after the super fund. And so with the super fund, they've gone, well, this $2 million or $2.5 million that's been contributed to the super fund. Did the trustees knowingly receive this, knowing that Mr. Rowley had committed this breach of trust and a breach of his fiduciary duty? But they said, Mr. Rowley certainly knew about it, because he was the one who made all of these breaches. So he knew about it, but the other individual trustees, well, they didn't really. even though there was an argument, well, really he was their agent because he did all the financial stuff. Everyone else just went along with it. The judge found no, that wasn't the case. They weren't aware of these breaches of trust, and so therefore the next level was, well, the super fund. Was it a volunteer? So had it received consideration? Had it provided consideration, for receiving this $2.5 million? And there's already a case of Cook and Benson, and that was with the larger superannuation funds before these changes to the Bankruptcy Act. And in that case, they were saying, well, a contribution to super, the super fund trustee does actually provide consideration because they're agreeing to invest the money in a certain way in accordance with all of the rules of the super fund. And there's also the consideration of, well, you've got to comply with all of those super rules, that we all talk about, and I'm coming back every year and telling you a few things that have changed. And so in this case, they said, well, that also applies to self-managed super funds. So the trustee of that self-managed super fund was deemed to provide consideration, and so Macquarie wasn't able to just get that money back under those principles. And so Mr. Rowley, if he's bankrupt, after the date of bankruptcy, well, he could pay a lump sum out to himself of his members' benefits and buy a big fat house next to the relationship manager. And so that's your super fund update for this